Good morning everyone, my name is Chris Santana and I'm a solicitor here at MJT Law. This morning I want to talk to everyone about what we call disclosure. So disclosure is a process which will either be ordered by the court or a commission or will be done just as a regular course during any sort of litigation. So disclosure refers to the process whereby the parties either deliver or produce all the documents that are in their possession or control and are relevant to the proceedings. So control here means obviously any documents that you physically have or are on your computers, but they also refer to documents which you are able to then get from, for example, your accountant. So when the time comes for disclosure, if you have passed on some documents to your accountants or to any other sort of service that you've used in the past, it's a good idea to contact them immediately just to give them a little bit of time to produce those documents as well. So the purpose of disclosure is to allow the parties to know firstly what relevant documents the other parties have, and it's also part of the process of each party telling their story, because by providing those documents the other side is then able to determine your side of the story and vice versa. So importantly, the obligation extends to documents that are also adverse to your case. So it's not a situation where you only produce the ones that are positive for your case and you hide away those that are negative and may prove fatal in the end. This is all part of what we would call cards on the table approach to litigation. So everyone puts their cards on the table. That includes their affidavits, their pleadings, their disclosure, and this allows everyone to understand each other and then helps them to come to a settlement, hopefully, which will then save them time and costs. So the way disclosure is usually done is usually by everyone providing a list of documents, which is essentially a contents page which lists all the documents that they've had, who produced them, and the dates of those documents. So I've prepared an example of a list of documents which I've used from a form from the Queensland Courts website. I encourage you to look at that on Google. So here you've got, the plaintiff here is Joe, and the defendant is James. And so you can scroll down and make sure to take note of all the areas that are covered in blue. They'll prompt you to amend the form as needed. So we've got here in the contents page, so schedule part 1. So we've got an email from Joe to James. The plaintiff was the one who created that document, and it's dated the 1st of January 2021. We've also got here a statement of claim. So the documents that need to be disclosed are also the court documents that may have already been filed. So affidavits, statements of claim, defences, responses, all these type of documents which may have already been filed. And then here we've also got another example of a document which frequently will need to be disclosed, and that's a recording of Joe. So although you are the one producing the document and disclosing it, here is Joe was the one who made the document because he was the one who recorded it, and it is dated the 1st of February 2021. Relevantly as well, you'll also see part 2, which is documents for which privilege is claimed. So not all documents which are in your possession, control, and are relevant to the proceedings need to be disclosed. Typically these are ones which legal privilege is attached. So you can see here in this table, we've got all emails, letters, correspondence, or otherwise sent to, in this case, MJT Law, but if you aren't using us, a different law firm. And then vice versa, any emails, letters, and correspondence or otherwise sent from you to us. So these aren't documents which would need to be disclosed. So when you're thinking about which documents to disclose and which ones are relevant, it might be important for you to remember what a document actually is. So we aren't just speaking about paper or emails or letters. So what a document is for the purposes of disclosure is any paper or other material which there is writing, any paper or other material which there are marks or figures on. So frequently you might have an amended contract which has been amended by hand, and then the parties have signatured or initialed the amendment. So that also would be relevant, as well as the original contract. And then lastly, we've got any discs, tapes, recordings, videos, sounds, images, pictures, any other sort of audio-visual type document which would also need to be disclosed. So these are all documents. The question also remains, what is relevant? So frequently you'll have a situation where every document that is in your possession might be relevant. So the question remains, what documents are relevant? So at the start of the litigation, both parties would have provided either a statement of claim or an application, and the other side would have provided either a response or a defence. So these would be considered pleadings, and in there are a number of allegations about certain matters of fact. So the disclosable documents which are relevant are ones which go directly to proving those allegations. So for example, if one of the allegations is that a contract was fraudulently amended, then that fraudulently amended contract would directly prove that allegation. When you're working with us as MJT Law, typically what I would say to our clients is to just send us every document that you have which relates roughly to the dispute, and then leave it up to us to determine which need to be disclosed and which are relevant. Please note though that by way of an extension of your duty of disclosure is the fact that while the litigation is on foot, you aren't able to destroy documents, and doing so would be considered a fairly serious offence and may actually warrant criminal action. So while the litigation is on foot, and until the matter is either settled or a court has determined a final outcome, just make sure you keep a copy of all the documents. However, a situation might also arise where you've already provided your list of documents, you've already provided all the your disclosure to the other side, but then more documents come in later which weren't previously in your possession or control, but are now. You have an ongoing duty of disclosure. So as that comes in, you would need to disclose these within a reasonable time period. So I would suggest you do so as fast as possible, as quickly as possible. And you would do so by amending your list of documents and then again providing that to the other side. Now, there are a number of ramifications if you fail to adhere to your duty of disclosure. So some examples are you may be prevented from using those documents as evidence if the matter progresses. You may actually be liable for contempt for not disclosing those documents. You may be ordered to pay costs if, for example, the other side needs to make an application to the court for you to then disclose them, as you otherwise failed to disclose them at your very first instance. And just lastly, the court may also order a staying or dismissing of all or part of your proceedings, which would mean you would no longer be able to continue the action. In summary, disclosure is unfortunately a very laborious and quite a costly exercise. It's unfortunate that at some stage in every litigation you will need to do so. Nevertheless, it is a very vital part of any sort of legal proceedings and can otherwise affect the outcome. If you obviously have any questions or you need our assistance, obviously please don't hesitate to contact our office and we'd be more than happy to help. Thanks.